We are meeting outside the presence of the jury. The record will reflect the presence of all counsel. Mr. Winslow is present. Mr. Carlos, I've been handed a change of plea form. My understanding is at this time the defendant wishes to enter a plea of guilty. Is that correct? Yes, sir. All right. Mr. Winslow, I'm going to ask that you stand and raise your right hand and be sworn.
You do state under penalty of perjury the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
All right, you can have a seat. At this time, Mr. Owens, I think you are moving to amend the information out of count 9. Is that correct?
That's correct, Your Honor.
All right.
The admission of guilt as to the felony sexual battery related to Jane Doe 1.
Okay, so at this time you move the court to allow the amendment of the information to add a count 9, which is violation of Penal Code Section 243.4, sexual battery with an offense date of March 17th, 2018, with the victim being Jane Doe number 1, a 54-year-old woman. Is that correct?
That is correct, and it would be the Penal Code Section 243.4, subsection A.
Okay, all right. And the court will allow that amendment. Is there any objection by the defense?
Oh, yeah.
Okay. With that said, then, the count 9 has been added to the information. And Mr. Winslow, I'm going to ask you a series of questions. All right, I've gone over your change of plea form. Have you had any drugs or alcohol or any narcotics at all within the last 24 hours?
No, Your Honor.
All right. I have in my hand a change of plea form. It's 4 pages long, and on this change of plea form, there are some initials on the right-hand side of the pages and a signature on the 3rd page. Is this your signature, and are these your initials on this change of plea form?
Yes, Your Honor.
All right, before you signed and initialed this form, did you have a chance to read what was on the form?
Yes.
And did you discuss the contents of this form with your attorneys?
Yes.
Do you thoroughly understand the contents of this form?
Yes.
And were you able to thoroughly discuss the contents of this form with your attorneys?
Yes.
Right, and I know we've had a long lunch hour and you spent the last, well, about 2.5 hours talking to your attorneys. Is that correct?
Yes.
Has that been enough time for you to make an informed decision about your decision today? Because the option is to go to trial. We have jurors out there waiting to start with opening statements in about 10 minutes. So have you had enough time to thoroughly discuss this with your attorneys?
Yes. Yes, Your Honor.
Okay. Well, I noticed you looked into the audience. So I'm asking you. I'm not asking anybody else because, sir, this is your decision and your decision alone. I think you understand that. Have you had enough time to discuss this?
Yes.
Okay. And you've also discussed it with your family as well, correct?
Yes, Your Honor.
Okay. All right. The form indicates that you are pleading guilty to counts 6, which is a violation of Penal Code Section 261A4, as well as the added count 9, and the stipulated state prison term would be a range from 12 to 18 years. Is that your understanding of the plea agreement?
Yes. Yes, Your Honor.
All right. And also that you would waive your appellate rights with respect to the charges that you have previously been convicted on with respect to Jane Doe number 3, Jane Doe number 2, and Jane Doe number 4, which were reflected in the verdicts on June 11th of this year. Do you understand that?
That's Jane Doe number 5, Your Honor, not 4.
I'm sorry. That's right. Jane Doe number 5. You understand that?
Yes.
Okay, so you would be pleading guilty to 2 charges today, and the prior convictions from the first trial, those verdicts that were read on June 11th of this year would stand, and you would waive your appellate rights on those charges. Is that your understanding of the agreement?
Yes, Your Honor.
All right. And the balance of the information would be dismissed. Is that your full understanding of the agreement that you're entering into at this time?
Yes.
Have any other promises been made to you to get you to plead guilty today?
That.
Finding the guilty verdicts were actually recorded on June 10th of 2019, if I just remember correctly. And the mistrial was declared on June 11th.
That might be the case. The change of plea form says June 11th. Let me take a look at the verdict forms. Are they in this one? Right, those verdicts were taken on June 10th and recorded on that day, so I'm going to change the 11th to the 10th. Is that your understanding of the plea agreement?
Yes.
And have any other promises been made to you to get you to plead guilty today?
No.
All right, you understand that the sentencing range would be a low term, the lowest possible term you could get is 12 years with a maximum possible term of 18 years, and you would present your evidence to the court. Mr. Owens would do the same, and then I would make a decision as to what the appropriate sentence would be, but it would be no less than 12 years and no more than 18 years. Is that your understanding of the plea agreement?
Yes, Your Honor, and I pray to God that you give me 12 and I can go home to my family as soon as possible, Your Honor.
Understand, and I will hear argument that your attorneys will make that would attempt to convince the court that 12 years is appropriate. Now, I need you to fully understand, I need to listen to me, that you could get 18 years, all right? You could get 18 years, you could get 12 years, and you could get anything in between. The way the plea is set up, you could have a sentence of 12 years, 13 years, 14 years, 15 years, 16 years, 17 years, or 18. And you have to be prepared for the court to impose any one of those possible sentences. Do you understand that?
Yes.
Okay. Has anyone threatened you in any way to get you to plead guilty today?
No.
Okay. And you understand that by pleading guilty, you avoid the possibility of spending the rest of your life in prison. Do you understand that?
Can you say that one more time?
By pleading guilty under these terms, you avoid the possibility of spending the rest of your life in prison.
Yes, Your Honor.
And you understand, I would imagine that's probably a motivating factor, correct?
It is.
Okay. All right. So do you have a full understanding as to the nature of the plea bargain and the terms of the plea bargain?
Yes.
Okay. Do you have any questions for the court about the plea agreement and or the sentencing range?
Have one moment here.
Yes.
I have no questions, Your Honor.
Okay. All right. And do you need to talk to your attorneys more?
He has done so.
Okay. All right. Then I need to advise you the maximum terms. The maximum term of this plea, as I mentioned, is 18 years, along with a fine of $10,000 and the possibility of a life parole period. Do you understand that?
Yes.
All right. You also understand that you would become eligible for the sexually violent predator law, which means that you could have a commitment after you serve your term for this case, if you are eligible and the people file a petition. Do you understand that?
Yes.
Okay. And you've discussed that with your attorneys as well?
Yes.
All right. You also understand that if you are not a U.S. citizen, that this plea will result in the deportation, exclusion from the United States, and denial of naturalization. Are you aware of that?
Yes.
All right. Now, I also have to go through your constitutional rights with you. Do you understand that the offenses that you are pleading guilty to are serious and violent felonies in the state of California? And in the future, if you commit another felony offense, your conviction in this case will result in substantially increased penalties and a mandatory state prison commitment and a denial of probation. Are you aware of that?
Yes.
Okay. Do you also understand that you do have the right to a public and speedy jury trial? In other words, you do not have to plead guilty if you don't want to today, because you do have constitutional rights, including the right to have a speedy and public trial by jury. In order to enter this plea, you have to give up that right. Do you understand that you do have the right to a speedy and public jury trial?
Yes.
And you give up that right so that you can enter a plea of guilty? Do you give up that right? Because you don't have to if you don't want to. As I said, we have jurors out there waiting, and they are willing and able to try this case. And it involves you having to waive your rights to a jury trial for me to, in order to accept this plea.
I guess I have to, Your Honor.
No, you don't have to. It's your decision. As I've said, we have the jurors out there waiting. Both sides are prepared to give their opening statements, and if you want to insist on your right to a jury trial, we are ready to give you a jury trial right now.
Your Honor, I would like to waive my right for a jury trial.
Okay. And let me explain why I'm asking these questions. As a judge, my most important task is to make sure your constitutional rights are being protected. All right? And I cannot accept a plea of guilty unless I can make a finding that you are making a knowing, voluntary, and intelligent waiver of your constitutional rights. So that's why I'm asking these questions. And I cannot accept a plea of guilty from you unless you waive your right to a jury trial. And that's entirely up to you. If you don't want to waive your right to a jury trial, you will get your jury trial. So, do you understand that you do have the right to a speedy and public jury trial to address whether or not these charges can be proved beyond a reasonable doubt?
Yes.
And do you now give up that right to a speedy and public jury trial so that you may enter a plea of guilty?
Is there any way I could get a couple minutes or no?
Well, I'm hesitant to do that because we've had the jury out there waiting now, and we started these discussions this morning. But I'll give you a short period of time, but I don't want to let those jurors sit out there and wait any longer, because I think the DA has their witnesses here. They're ready to start the trial. And Mr. Winslow, I felt like I gave you ample time to discuss this with your attorneys. And I know that you had family members in here over the lunch hour that were present during the conversation as well, because I wanted to afford you the opportunity to make this very important decision. So why don't we take a short recess? We'll be in recess till 1:45, but I'm going to also ask you some other questions, Mr. Winslow. I'm going to ask you if you give up your right to confront and cross-examine witnesses. I'm going to inform you your right to remain silent, that you can testify on your own behalf if you'd like to. And you also have the right to present evidence on your own behalf and use the subpoena power of the court to subpoena witnesses to come in and testify. Those are all essential constitutional rights that you have. Unless you're willing to waive those rights, I cannot accept your plea of guilty. So we'll be in recess till 1:45. I'll have counsel go back with you and talk with you some more, but we need a decision by 1:45. And I know it might appear that I'm rushing you, but we've been talking about this all morning, and I have to be mindful of the jurors that have been sitting out there waiting. So we'll be in recess till 1:45. We'll be in recess till 1:45. We'll see you then. Back on the record, the record will reflect that we're meeting outside the presence of the jury. All counsel are present. The defendant is present. And Mr. Winslow, have you had some time to discuss this with your attorneys? Yes. Again, and I know it seems like I may be rushing you, but we have the jurors out there waiting, and we've been talking about this all morning long. And like I said, I gave you 2.5 hours over the lunch hour, and I made the courtroom available for you, and I think your mom and dad were present, correct?
Yes, Your Honor. Yes.
Okay, and that's why I know it's a very important decision for you, and it may seem like you're being rushed, but we need to make a decision because I just talked to counsel. Mr. Owens, are you ready to give your opening statement?
I am.
All right, and Ms. Von Helms, are you ready to give your opening statement?
I am, Your Honor.
If you do not want to waive your rights, we are going to start this jury trial right now, and both sides are prepared to proceed. And if you do not waive your right to a jury trial, you're going to have a jury trial. Do you understand that?
Yes.
Okay. So I need to ask you, do you understand that you do have the right to a public and speedy jury trial?
Yes.
I'm sorry?
Yes, I do.
And do you now give up that right so that you can enter a plea of guilty to count 6 and count 9 and waive your appellate rights to the charge that you've been previously convicted on?
Yes.
Okay. You also have the right to confront and cross-examine all witnesses against you. That's a constitutional right that you have. Do you give up that constitutional right so that you can enter a plea of guilty to these 2 charges?
Yes.
You also have the right to remain silent unless you choose to testify on your own behalf. Do you give up that right so that you can enter a plea of guilty to the 2 charges?
Yes.
You also have the right to present evidence on your own behalf and use the subpoena power of the court to compel witnesses to come forward and testify on your own behalf. Do you understand that you have that right as well?
Yes.
And you now give up that right so that you can enter a plea of guilty to these charges?
Yes.
All right. Do you also understand that between now and sentencing, if you commit another crime, that the sentencing portion of this agreement will be canceled, and I will be able to sentence you to a greater term in prison, and you will not be able to withdraw your plea of guilty. Do you understand that?
Can you repeat that once again?
Yes, so if you end up pleading guilty today, we're going to set your sentencing out to some date in February. If between now and February you commit another crime while you're in custody, and there are crimes that are committed while in jail, that your plea will remain, but the court would not be limited to the 18-year lid. The court could sentence you to more than 18 years. That's only if you commit a new offense between now and the sentencing date. Do you understand that?
Oh, I understand.
Right, and you initial that box. It's called a cruise waiver, and
Okay.
you initial that box. All right, so you agree to that, correct?
Yes.
And there are a number of other consequences to the plea that you circled in paragraph number 7F. Do you understand all those collateral consequences of the plea, the possible consequences of your plea?
Yes.
All right. Do you have any other questions of the court before the court accepts your plea of guilty?
You said, do I have any more questions?
Do you have any questions of the court about your plea?
No.
All right. Do you own, possess, or have under your custody or control any firearms, ammunition, or ammunition-feeding devices, including but not limited to magazines? Do you have any of those in your possession or within your control?
No.
All right. Okay, then, Mr. Winslow, let me ask you this. With respect to count 6, which alleges on or about and between June 20th, 2003 and June 21st, 2003, you did unlawfully and have and accomplish an act of sexual intercourse with Jane Doe number 4, a 17-year-old minor, and a person not your spouse, when the person was at the time unconscious of the nature of the act, and this was known to you. How do you plead to count 6? Guilty or not guilty?
Guilty.
And with respect to count 9, which is an added count that alleges on or about March 17th, 2018, you did unlawfully commit sexual battery against Jane Doe number 1, a 54-year-old woman. How do you plead to that? Guilty or not guilty?
Guilty.
I'm sorry?
Guilty.
Okay. And also, do you agree then that the verdicts that were recorded on June 10th with respect to Jane Doe number 2, Jane Doe number 3, and Jane Doe number 5 will stand, and you waive your appellate rights with respect to your convictions in those cases, those charges?
Yes.
All right. The factual basis reads as follows. With respect to count 6 of the second amended consolidated information, I unlawfully had sexual intercourse with Jane Doe number 4 when we were both teens. She was 17, I was 19, and she was not my spouse. She was at the time unconscious, and I do not dispute her memory for purposes of this plea. Did you in fact do that, those facts that make you guilty of this crime?
Sorry, I'm just not thinking very clearly. right
Okay,
now.
so, well, I read the factual basis was on the change of plea form that you initialed, and as I just read it to you, it alleges that you did certain acts that formed the basis for your conviction of count 6. So I need a factual basis for this crime, but if you don't want to admit to a factual basis, we don't have to take the plea. And both sides are ready to proceed with your trial. I'm not pressuring you, I'm just reciting what's on the change of plea form that you already initialed. If you don't want to agree to those facts, you don't have to.
Yes.
Yes, what, you do admit that you committed those acts that make you guilty of count 6?
Yes.
All right, and then with respect to the amended added count number 9, which is the sexual battery, the factual basis states as follows. I touched an intimate part of Jane Doe number 1 while she was restrained in fear against her will for the purpose of sexual arousal. Do you admit that you committed those acts that make you guilty of count 9?
Yes.
All right. Mr. Carlos, do you concur in the plea?
Yes, Your Honor.
Ms. Von Helms, do you also concur in the plea of your client?
Yes, Your Honor.
All right. The court finds that the defendant has made a knowing, voluntary, and intelligent waiver of his constitutional rights, and the court hereby accepts his plea of guilty to count 6 and the added count 9 of the amended information. Is there a motion on behalf of the people with respect to the balance?
Yes, there will be one forthcoming, Your Honor. However, I noted when the court was taking the change of plea that I think we needed admission to the 803F allegation regarding count 6. Once we could do that, the people are prepared to make a motion to dismiss the balance.
That's correct. There was the allegation with respect to the statute of limitations. That's not on the change of plea form, however. There is an allegation under Penal Code Section 803F that the offense involves substantial sexual conduct as defined in Penal Code Section 1203.066B, and that there is independent evidence that corroborates the victim's allegations within the meaning of Penal Code Section 803F. Do you admit or deny that allegation?
I admit.
All right? The court will accept that admission. Let's have you add it onto the change of plea form and initial it. I'll wait for that now. Mr. Owens, do you want to add it?
However the
Or-
court would like us to. I can initial it once it's been
Okay.
allocated.
Do you have the change of plea form then?
Yes, he's initialing, Your Honor.
Okay. All right, the court notes that the allegation has been added with respect to count 6, and the court did take the admission. With that said, Mr. Owens, is there a motion on behalf of the people for the balance of the information?
Yes, thank you, Your Honor. The people move to dismiss the balance in light of the plea to the 2 counts that are listed on the felony change of plea form.
All right, those remaining counts will be dismissed. The case is referred to probation for a sentencing report. We did discuss sentencing dates, and we have agreed on February 18th. Is that correct, Ms. Von Helms?
That is correct, Your Honor.
And Mr. Carlos?
19th.
We agreed on Wednesday, the 19th, if that's possible.
That's fine. That'll work. Okay. So probation hearing and sentencing will be on February 19th. Mr. Winslow, you do have the right to be sentenced within 20 days of today's date. Do you give up that right so that instead your sentencing can be heard on February 19th, the year 2020? It'll be at 9 o'clock in the morning?
Yes.
Okay, we'll show a time waiver then to February 19th with respect to a scheduling for any filings that you might want to do. The deadline will be January 31st, 2020, the close of business. All written motions and supporting documents in support of your arguments for sentencing must be filed by January 31st. All responses are then due February 7th by close of business, and then we will have the sentencing on February 19th. That will be at 9 o'clock in the morning in Department 12 up here in North County. All right? What? 9 a.m., yes, Department 12, 9 a.m. The defendant will be held without bail pending sentencing. Are there any further requests with respect to the plea?
No, Your Honor.
No? All right,
Thank you.
let's bring in the jury. All right, the record will reflect that all jurors are now present. I know this trial is just at the beginning, has been marked by a bunch of delays. I know you've been waiting out there for a half hour. I'm about ready to tell you why you've been waiting so long. Since this morning, we were having some discussions about a possible change of plea. And while you were away at lunch, that has taken place. So we just took a plea of guilty to certain charges. And what does that mean for you? It means that you do not have to serve on this case and that your jury service is complete. I know I've been admonishing you repeatedly. I know a lot of you started your jury service 2 weeks ago today, right? Some of you were here 2 weeks ago Monday, some of you 2 weeks ago Tuesday, and 2 weeks ago Wednesday. And I've repeatedly admonished you not to talk about the case with anybody, not to read any news accounts of the case, not to look at any newspaper articles. You are now released from that admonition because there is no need for a jury trial. Now you might think to yourself, well gosh, I just wasted 2 weeks of my life sitting around outside the courtroom and inside the courtroom asking questions that are very personal in nature about your background and so forth to make sure that we could get a fair and impartial jury. We started with 172 jurors and ended up with 16. Both sides agreed that you could all be fair and impartial in this case, and I want to give you my thanks for being willing to serve on this case. There are, as citizens, there's only two mandatory things that we must do, duties as citizens. One is to pay taxes, and the other one is jury service. Voting is even voluntary. Military service is voluntary, but this is the one opportunity that you have as a citizen to fulfill your duty that does not involve writing a check to the government, that really fulfills your obligation as citizens. I want to tell you how much I appreciate that and how much I appreciate the time that you've taken from your day, away from your families, away from your jobs. Some of you who are retired, I'm sure you'd rather be out playing golf. We took time away from the golf course, but I really want to let you know how much we appreciate your willingness to serve on a case certainly of this magnitude, and then try and keep your head pointed away from the TV set and the newspapers. So thank you again for your willingness to serve. You are no longer bound by my admonition. You can talk about the case with anyone you want, and the case is over. So your jury service is complete with the thanks of the court. So have a nice day. Thank you very much. All right, the jury has left the courtroom. We will see everybody back here February 19th at 9 o'clock in the morning in Department 12. Are there any further requests by the people?
Not at this time, Your Honor. I would just alert the court. I would estimate that in terms of the people's presentation, that the estimate for that hearing may take up to an hour.
Okay. And
It would take probably an hour or 2 hours at the most.
I'm going to set a half-day time estimate for the hearing on the 19th. Are there any further requests by the defense?
No, you're not.
No? Okay. I'm sorry?
No, Your Honor.
Okay, good luck, Mr. Winslow. We'll see you back in court on February 19th. We're in recess.
Okay.